If there's one thing architects love, it's their letter agreements. No matter how many times I try to tell architects not to use letter agreements, basically every architect I know, succumbs and uses letter agreements more often than not. A letter agreement is another way of saying or having the same meaning as a proposal form. When an architect submits a proposal form and requests that the owner who he submitted the form to signs the form to show his agreement, that becomes a letter agreement. It's a written contract that is valid. So I can't overstress how often we get cases due to faulty letter agreements. Letter agreements, the way the architects are normally preparing them, are warm and fuzzy. They're friendly in nature. They try to make the owner feel good. The architect is so pleased to get this project. He's just bubbling over with excitement, and he's raring to go. However, it doesn't discuss what he's doing for the fee that he's asking for. And this disparity here, the fee and the services, is ripe for conflict and a lawsuit. I would highly recommend that if you're going to use a letter agreement, that you retrieve a reasonably decent association agreement to use as a reference source to make sure that you're covering the basic subject matter of any well-prepared agreement. Things such as the actual date that the agreement begins, the scope of your services, the amount of fee you're charging, when the payments are due, whether you'll be involved in any construction observation, what the limits of your liability exposure are, that being you are not in charge of construction means, methods, techniques, sequences, safety procedures, or precautions. You have to make that clear to the owner. You're strictly a design professional. You are not having anything to do whatsoever with construction of the actual project. You should have a termination provision. You should have a description of what your basic services are so that they are specific, and anything that is not described in your letter agreement that needs to be performed at a later date should be performed as an additional service. The agreement should say what you're going to charge for the additional services. By the time you get through putting in all the necessary ingredients in your letter agreement, you might as well use a properly prepared association agreement, which has been tested by the court system, in numerous cases, and you'll be better off doing that. Being warm and fuzzy will just help you become sorrowful when the lawsuit comes in.